Welcome to Chapter 9 devoted to legal aspects of project procurement management. This video presentation, just like all video presentations in this course, are based on project procurement management, contracting, subcontracting, teaming by Quinton Fleming. After completing Chapter 9, you should be able to explain why a project manager must be knowledgeable in legal matters surrounding procurement. You should be also be able to explain what contract is in essence. You should be able to provide an example of a principal-agent relationship and explain why this relationship is so important in business, but especially in procurement management. Also, you should be able to explain why interests of principals and agents may not align. So this is one of the most important theoretical problems behind contractual law or behind a contractual relationship. You should be able to explain the purpose of the Uniform Commercial Code or UCC. You should be able to explain the purpose of the Federal Acquisition Regulations or FAR system. And also you should be able to provide examples of special contractual terms. So those are the learning outcomes for Chapter 9. Unlike performing work internally, procuring goods and services from outside creates a legal relationship. This is what it means. When you work within one single organization, then the lines of authority, meaning your formal post or your formal title within an organization, allows you to monitor, to control, and to give orders to people below you or to people who work with you in this particular organization. However, when you're working with somebody who is outside of your organization, meaning you're subcontracting work to somebody or you're contracting work to somebody, then there are no formal lines of authority. Your title within your organization does not really give you the right to monitor, to control, or to give orders to people from the outside of your organization. So if that's the case, if you're working with somebody from the outside of your organization, then you need to introduce those lines of authority and accountability and responsibility by forming legal relationships, by signing a contract. Since there's so much ambiguity surrounding those legal relationships I'm talking about procurement relationships. So there's a lot of misunderstandings or legal ambiguity surrounding the legal forces that govern a relationship in a procurement. And because of that, many procurement contracts end up in court where attorneys from both organizations represent the interest of their respective organizations. Because of that, because there are a lot of legal considerations surrounding procurement relationships, and unfortunately, oftentimes those legal matters are disputed in court, a project manager needs to become somewhat knowledgeable in legal matters surrounding procurement by becoming a type of an amateur attorney. So once again, contract law is central to procurement management because if you're procuring something, most likely you will do it under a contract. So it is very important to understand the laws and legal regulations and various legal practices surrounding contractual law for a project manager. There are many definitions of a contract, but most people have a rough understanding of what a contract is. They understand that this is some kind of agreement between two parties to work together, or an agreement between two parties where one party is promising to deliver something to another party in exchange of payment. So people have a rough understanding of what a contract is. However, very few people understand the details. Very few people understand what it takes to form a contract or when a contractual relationship is entered. A project manager should understand when him or her or the entire project team organization have met the test of forming a contract and when they have not. So in other words, the details of legal arrangements surrounding contracts needs to be well understood by a project manager. Otherwise, all kinds of dangerous situations are possible. For example, one of those situations is a project team or the organization where this team is working may enter a contractual relationship with another organization without even knowing it. They may not even understand that they are now under a legally binding agreement in the form of a contract if they don't know all those details surrounding contractual law. So let's start with basic definitions. Project Management Institute provides a rather narrow contract definition. So this is the definition from PMI. A contract is a mutually binding agreement that obliges the seller to provide the specified products and obliges the buyer to pay for it, to pay for the product or service provided by the seller. This definition is a bit narrow because it assumes that a contract is largely about buying and selling goods and services. You know that some relationships, some procurement relationships, they're not really about buying goods and services. For example, under the so-called teaming arrangement, the agreement is to work together and not necessarily to buy or sell goods or services. So that's why we need to have a broader contract definition. And one way to define a contract in a way that encompasses all or most procurement relationships is as follows. A contract is an agreement between two or more people which creates an obligation to do or not to do a particular thing. So that definition is much broader. Some essential components of a contract are as follows. First of all, you need to have two competent parties entering the agreement. In other words, both parties need to have the understanding of the agreement that they're signing, that they're entering, and also they need to have the authority and the mental capacity to enter such agreement. Also, a contract needs to include a subject matter, which means that a contract needs to be specific. It needs to contain specific terms and conditions. In other words, what exactly are we agreeing to do? So it needs to contain this subject matter. It also needs to contain a legal consideration. A legal consideration is typically defined in terms of the benefit being exchanged. So a legal consideration means I promise to give you some benefit, let's say in the form of a product or service, and you promise to give me some benefit in return, such as payment. So there needs to be some kind of exchange of benefit involved. Also, the agreement has to be mutual. In other words, both parties need to agree, otherwise it's not a contract. And also, there needs to be mutuality of obligation. In other words, there needs to be something done on both sides. A contract cannot be one-sided, where one party is obliged to do a number of things and the other party is obliged to do nothing, right? So there needs to be a mutuality of obligation. To expand on this definition, we can create the following list of criteria that a contract must meet in order to be considered a valid contract, and we'll go through this list one by one. Number one, a contract is an agreement between two or more parties. So there needs to be an agreement where two or more parties agree to work together. You cannot have one party agreeing to work with itself, something like that, right? So typically we need two or more parties. The parties must have legal, mental, and age capacity to contract. So, for example, minors cannot sign contracts. Somebody who has been, proven by qualified medical doctor to be, not to be in the kind of right mental capacity to make sober judgments about business relationships. So if we're talking about a mental disease on the side of one of the parties, then of course such contract is not valid. You cannot have people who don't have adequate mental capacity to sign a contract. Also, a person signing a contract must have a legal capacity to sign a contract. In other words, he or she must have the authority to represent a particular organization and sign agreements on behalf of that organization. Also, within a contract, the parties must promise to do or not to do a particular thing. So there needs to be some kind of specific obligation or specific term or condition in the contract. It cannot be a general contract. Let's just work together and do great things together. That's more along the lines of a memorandum of understanding or letter of intent or something like that. A contract needs to have specific promises. There must be an offer communicated from one side. So one side needs to say, okay, I'm offering you to do this, right? Without this specific offer, a contract cannot be considered as specific and valid. Also, there must be an unconditional acceptance of that offer by the other side. So the other side may say, okay, I agree to this offer. Now, if there's any kind of modification of an offer or partial acceptance, then the contract is not signed. So if there's any kind of disagreement or partial acceptance, then it's a counter offer. And then a new contract needs to be put together based on that partial agreement or counter offer. So the process of forming a contract does not take place until there's an offer given and unconditionally accepted by both parties, right? By the other party. Okay. So any kind of deviation from that offer requires writing a new contract. There must be mutual assent by all parties. The parties must agree on the same thing. So both parties need to agree to the content of the contract, otherwise it's not a valid contract. The contract, in fact, all contracts must be supported by consideration. By consideration, we mean some kind of exchange of value. There needs to be that exchange on both sides. However, this exchange does not have to be of equal value, right? So, for example, you need to say, one consideration coming from one party is that I provide a particular service, then the other party agrees to pay for it. The payment and let's say the service expressed in terms of cost does not have to be equivalent, but there needs to be a benefit offered on both sides. So that's what is meant by consideration. Also, the contract must be for a legal purpose. You cannot sign a contract for something that is illegal. Otherwise, even if the form of the contract is valid, the contract is still invalid, because a contract cannot be signed for something that is prohibited by law. The agreement must be in the form as required by law. For example, some situations, some industries require the contract to be in writing. For example, in real estate transactions, some contracts are required to have time periods exceeding a certain duration. Some contracts require to have specific dollar amounts. Something in relation to the amount of money that is involved. So different industries, different companies have to meet different regulations when it comes to the specific form of the contract, and this is often dictated by law. So those criteria, together with the broader definition that we have covered, explain the essence of a contract, what a contract is. One important theory underlying contracts and contractual relationships is the so-called principal-agent theory. This theory, I believe, came from economics, and it's a very fundamental theory that has a number of implications in many areas related to economics, such as business, management, law, and many other fields. So it's a theory that has a lot of practical implications, and also this theory is surrounded by practical agency law that governs a lot of the contractual relationships. And we will try to, first of all, to explain what principal agency theory is, and also some of the most fundamental laws or legal ideas arising from a principal-agent relationship. So this theory is very fundamental to contracts and any kind of business or non-business relationships involving contractual obligations. So I think the best way to explain the principal-agent theory is by defining the two terms comprising the name of the theory. So who is an agent? An agent is the individual or organization authorized to act, to do something for another person. And that other person is the so-called principal. It's the individual organization for who the agent acts. So a principal-agent relationship is something along the following lines. You have a principal, like a boss, who delegates, who authorizes an agent to do something on his or her behalf, on behalf of the principal. Now, why this agent-principal relationship is so important? Well, doing business requires delegating work to others. For example, shareholders, meaning owners of a corporation, they delegate to managers the authority to manage their investment on their behalf and in their best interest. So this is the essence of business. This is the essence of management. Shareholders are investors. They invest their money into an enterprise. Oftentimes, they do not want, or they cannot manage their investment. Okay? So to manage their investment, investors, they hire managers. So managers, they're agents that are hired by the principals, which means investors in this case. Okay? So the most important question, the holy grail, the most important issue arising from this principal-agent relationship is this. How do we make sure that the interests and actions of principals and agents are fully aligned? In other words, how do we make sure that agents do what is good for principals and not what is good for agents, and a worse scenario, something that is actually contradicts the interests of a principal. So let me give you a specific example of that. So shareholders hire managers to run an enterprise, and then managers out of the sudden decide to buy a brand new state-of-the-art luxury corporate jet for themselves. Okay, now in a way, managers, they have this authority. They have this authority to buy things for the organization, including maybe buying a corporate jet. But does really buying a luxury corporate jet, which relies on the latest technology and has luxury interior, in the best interest of shareholders or the principals? Well, probably not. Probably not. So how do we prevent agents for doing something that may not be in the best interest of the principal? So that's the most important question in a principal agency relationship, and contractual law is largely about that. I mean, it's largely about specifying all the details, all the nuances, clearly listing terms of and conditions, so that the agent is constricted to act only in the best interest of a principal. So it's a very important fundamental theory. There's a lot of research being done in this area, and one thing that I find interesting about this whole area is this: no matter how detailed you are when it comes to creating laws and regulations governing the work of an agent, so that the agent acts in the best interest of a principal, no matter how much time you spend, I think ultimately it comes down to the morals, to the ethical principles guiding the work of an agent. Because an unethical agent will always find a way to somehow circumvent any kind of legal agreement, right? Or they will just ignore it and steal money from the principal and run away, right? So it's something, despite the fact that the focus of contractual law is on that external punishment, I think it's something that comes from the inside of an agent, right? That makes the agent compliant with those legal requirements, and overall makes the agent work and act on behalf of the principal in a way that is in the best interest of the principal. And there are many great examples of that. One of those examples is Enron. Enron was a huge energy company headquartered in Houston. To make the story short, the company went bankrupt because of illegal business and accounting practices, mostly on the side of Enron managers. And that's when everybody realized that you may have brilliant people, and most people who were in charge of Enron, they were brilliant, they were very smart, they were very educated, very experienced, but it comes down to ethics, right? They didn't have enough ethics, enough understanding of business ethics, or enough internal sense of what is right or wrong to avoid small ethical problems that eventually snowballed into outright fraud. Okay, and after the Enron scandal, which happened, I believe, in 2001, a lot of business schools around the globe they came under fire for not teaching managers, MBA graduates or master's level students, the principles of ethics. By the way, Jeff Skilling, the CEO of Enron, he had an MBA from Harvard Business School. In fact, he was one of the top graduates from Harvard Business School in the entire history of this business school. And yet that did not prevent him from committing a number of ethical crimes that eventually snowballed into outright accounting fraud and led him being in prison for 27 years or 28 years, I believe. I think he just got out recently because he got out on a parole or something like that, but he didn't serve the entire sentence. So another example of a take or perspective on principal agent theory comes from Warren Buffett, who is one of the most successful investors of all time. And that's what Warren Buffett is saying. In essence, he's saying, well, contracts, they're all nice, but he says that I will not work with somebody I don't trust in the first place. So a lot of the business deals that Warren Buffett has been involved, they didn't include lawyers. He would just sit down with a business owner and draft a contract, draft an agreement on a computer, then sign it, and that's it. Because he believes that no matter what kind of legal team you have, no matter how many lawyers you hire, if somebody is unethical, then they will find a way to circumvent that contract, that legally binding agreement. And on the positive side, if you have somebody ethical, if you have somebody you trust, then you don't need to have a team of lawyers. You don't need to have any formal contracts to work with that person. So one company that he bought in this particular fashion was Nebraska Furniture Mart, a furniture company that was run by a lady, an immigrant from Russia. And she ran this company for many, many years before she became too old, and she decided to sell most of the company to Warren Buffett. Apparently, there was a mutual sympathy where she liked Warren Buffett. She thought that he was a very ethical investor, and she felt comfortable selling the work of her life to him. And the same kind of respect was on Warren Buffett's side, where he believed that she was a very good business person, somebody who can be trusted unconditionally. So that's why they didn't do any due diligence. They didn't hire any lawyers. They just sit down together in Warren Buffett's office, and he quickly typed the agreement together with this lady. Her last name was Blumkin, and that's how the deal was made, right? So some interesting practical takes on the principal-agent theory. I find it interesting because a lot of research there about contracts, while the practice seems to be more about human morals and human values. So some fundamental ideas that arise from this principal-agent theory and research. I'm talking about ideas that are of immediate practical value to project managers. You see, agency law is important for project managers because project managers delegate work on the project to others. For example, when a project manager authorizes a budget for another person, an agency relationship is formed. So agency law, meaning the specific legislature, the specific laws arising from this principal agent theory, covers the relationship between two persons whereby one person is authorized to act for and on behalf of the other person. Now those those legal ideas are very numerous. We'll just discuss one idea that is central to the principal agency theory. And those ideas are related to the authority conveyed from principal to agent relationship. So in other words, what are the things that an agent can or cannot do? So this is one of the central questions, and that's why contracts are signed, to specify what agents are authorized or not authorized to do. Under the agency law, there are the following common types of authority given to an agent: express, implied, and apparent. And those types of authority, they govern, they determine what an agent can or cannot do. So we'll talk about each of those types of authority in more detail in a couple of minutes. But before we talk about the details, I would like to know that this is like a sorted order. Express is the highest form of authority, while apparent form of authority is the weakest one. So let's talk about express authority given to an agent. This is the highest form of authority that can be given. It is given by the principal specifically conveying to the agent authority to act for them by either spoken or written communication. So if you're talking about a contract, then it's a written communication. If it's a verbal agreement, then it's a spoken communication. I'm not a lawyer, I'm not a big expert on legal matters, but I know that in the United States, it's one of the countries where a verbal agreement can also be treated as a legally binding contract. So it doesn't have to be in writing. But in most countries, I think, in order to be prosecuted for breach of contract, it needs to be in a written form. It cannot be in a verbal form. So, under express authority, the delegation of authority to buy on behalf of a company, it's an example of express authority. Now, most managers, they lack the authority to buy goods and services, and this authority is typically delegated in an express fashion to the procurement professionals, and they're the ones called buyers. In government, those with a job similar to contracting officer may authorize new work or purchase for the government. So express authority is the highest form given to an agent. And unfortunately, most project managers they lack this express authority to buy goods and services. They have to do it through someone who actually has this express authority, and typically it's somebody from the procurement department of the organization. Now, implied authority is a bit weaker. It's a weaker form of authority given to an agent. So sometimes an agent can act on someone's behalf without formally receiving this authority in written or verbal form. And this is the type of authority a project manager often has within an organization. For example, when a project manager is appointed, there may be a formal written declaration that the person is authorized to manage a particular project. But there may be little specifics beyond the appointment of the project manager to be in charge of this project. Still, despite this explicit written authority to do something, there may be numerous implied authorities delegated to the project manager. For example, creating budgets, creating schedules, calling status meetings. It may not be a part of a formal agreement between the project manager and the organization who hired the project manager, but it's implied that a project manager can do things like that. And then you have apparent authority. It's the weakest form of authority given to an agent. It's the most ambiguous, delicate, and problematic type of authority, to expand on that. Sometimes individuals can assume authority to act as agent for a principal by virtue of circumstances. So they can have apparent authority not as a result of any specific delegation, but by virtue of the principal's silence on the subject. If the circumstances are such that a reasonable person could conclude that one has authority and no one says otherwise, apparent authority to act may come into play. Oftentimes, this apparent authority is manifested or is derived from somebody's official position or title within an organization. This is an example of an apparent authority. A CIO or Chief Information Officer may tell a project team to adopt a different technical approach due to his or her apparent authority over technical matters within the organization. This may be a valid suggestion. So if the project manager does not explicitly disagree, so there's a silence, and the CEO, let's say, of the organization, they don't explicitly disagree with the CIO's authority to give orders to the project manager regarding technical matters, then this order can be given from the side of apparent authority. So it's something that the CIO can do. However, if there is a strong objection, let's say, from the organizational side, where there's a policy that says that when a project manager works on a project for the organization, then the project manager has ultimate authority on technical matters, then there's no silence, right? Then there's a contradiction to the CIO order. But typically, people with titles like that within an organization, they have this apparent authority to give orders like that to project managers. I think a rule that is related to courtesy is that yes, a CIO can issue orders like that, but it cannot be done behind the back of a project manager. As long as it's a valid suggestion and the project manager is informed, then we can consider that the CIO has this apparent authority to give orders to an agent. So those are the three forms of authority given to an agent, and this is just an example of an agency law. As I said, this field is vast. There are many ideas, there are many theories that come under the umbrella of principal agent law. So we just saw like some examples of types of authority delegated to an agent and how it impacts the relationship between a principal and an agent. Up to this point, we've been talking about some theoretical or legal ideas surrounding contracts or principal-agent relationship. So now we'll talk about specific regulations, specific laws that govern procurement, specifically the contractual relationships that arise from procurement transactions. One of those laws or sets of laws is the so-called Uniform Commercial Code, or UCC. The Uniform Commercial Code was created in 1951 in the United States to standardize commercial relationships, although many other jurisdictions, many other countries seem to subscribe either explicitly to UCC or some modified form of thereof. By the way, not all states in the United States adopt UCC, there are some exceptions. In the United States, at least, all commercial procurements are subject to the laws specified as a part of UCC. One major exception is procurements related to government. Those procurements are often governed by the Federal Acquisition Regulation so far. Now, Article 2 of the UCC Uniform Commercial Code is especially relevant because it's related to sales. So when you're procuring something, be it goods or services, you're entering something that resembles a sales transaction. Now UCC is still evolving. You can look at the UCC code here using that link, but there are still groups and organizations working on refining and extending the UCC. So it's still a work in progress, just like any legislature. So let's look at some of the most important articles in the UCC. We'll just list them one by one and try to explain how they relate to procurements. For example, notice of termination. If one party wants to terminate their relationship with another party, it must notify the other party. Silence alone will not terminate an agreement unless the two parties previously agreed on that. So for example, you're doing business with a particular organization and then after some time you no longer wish to do business. You cannot just disappear and hide from your business partner. You need to notify the partner that you're terminating the relationship. Silence alone is not an adequate ground to terminate a relationship. Warranty of title. The seller must possess a title to a product that can be transferred to the buyer. The title needs to be free of liens or encumbrances. What it means you need to be selling something that you own. You cannot sell something that you don't own, or something that you own but there are some other alternative claims to your assets which you're trying to sell. Then if you're trying to sell something that you don't own or something, some assets against which other parties have claims, then you cannot sell it. I mean, this is not a valid form of a contractual agreement. If you're trying to produce a contract that involves you selling something that you cannot possibly sell. Express warranty. An express warranty is created when the seller makes a statement of fact or promise about the product sold. For example, if you're saying that this lawnmower will last at least 12 months, then this is an express warranty, and your goods and services needs to comply with this warranty. By the way, a description of the goods sold or a sample may also constitute an express warranty. In other words, if you're giving something to a potential buyer as a sample, and this sample has a certain characteristic, then it's the same as giving an express warranty, because the buyer will assume that whatever he or she will be getting from you will be the same as the sample. Now, the warranty does not has to be expressed. Sometimes it's implied. Goods sold should serve the purpose for which they're intended, even if there's no express warranty being given. For example, if you're selling a lawnmower and then somebody buys your lawnmower and then it doesn't work, it doesn't cut grass, then you cannot say that the sales transaction is valid because you didn't have an express warranty that this lawnmower will cut grass for any particular period of time. Now the thing is, there's an implied warranty being created because somebody who buys a lawnmower assumes that the lawnmower can be used to cut grass at least for some period of time. Okay. At the same time, express warranty has precedence over implied warranty. So whatever is expressed explicitly as a warranty has precedence over assumptions or something that is implied by a sale or product description or a sample. Buyer's right to inspect goods. The buyer has absolute right to examine goods before buying. However, there are some exceptions because buyers also have some responsibilities when inspecting goods. For example, inspection should be done within a reasonable time after delivery. Otherwise, the inspection is assumed to have taken place. In other words, you cannot wait for 10 years and then say, by the way, your lawnmower is not working. It has to be done within a reasonable time interval following a purchase. Inspection must be consistent with what the goods were originally purchased for. New, more stringent requirements should not be added. If you bought a lawnmower for cutting grass and then you're complaining, then the lawnmower is not good for cutting down bushes, then this is not a fair test, not a fair inspection of the product, because originally the product was intended to cut grass and not to cut bushes. If goods are not acceptable, a notification should be made to the seller. Again, seller needs to be clearly informed about the goods not meeting a particular standard or expectation from the buyer. Silence alone is not enough to make an explicit statement that the inspection detected some problems with the good or service. Liquidation or limitation of damages. This article covers damages caused by a breach of contract, meaning failure of one party to comply with the contract. by either side, and also settlement of the damages based on an agreed formula specified in the contract. In other words, this article is designed to protect both parties from breaches of contract or unreasonable claims in relation to the damage that is caused by a breach of contract. So this is what this article states. Damages for breach by either party may be liquidated in the agreement only at an amount which is reasonable in the light of the anticipated or actual harm caused by the breach. A term fixing unreasonable large liquidation damages is void as a penalty. So basically, to rephrase it in common language, it means that yes, if there are damages caused by the breach of contract, by the failure of one party to comply with the contract, then those damages, they need to be compensated, but they need to be compensated at an unreasonable amount. I mean, you cannot sue somebody for $1 million because they sold you a faulty lawnmower, right? Because $1 million is not a reasonable amount to compensate you for whatever damages you have experienced as a result of your inability to cut down grass with this lawnmower. So what would be like a reasonable compensation for a faulty lawnmower? Let's say, the time that you spent buying another lawnmower, or the money that you spend hiring another person to mow your lawn because the lawnmower that you bought was faulty. Those are reasonable compensations. But suing somebody for $1 million is unreasonable because this is amount that is not proportional to the damages that were caused to you by this breach of contract. Now, some clarification is required to explain what is reasonable and what is not. Generally, there are two types of damages being discussed when a contract is breached. First, you have compensatory damages, compensatory damages, also called actual damages. They are awarded to cover actual losses sustained. The compensation is meant to make the person whole again, but not to enrich a person. For example, if someone crashed into your car and you spend $10,000 on hospital bills, then this amount can be awarded to you to make you whole again, to compensate you for the damages. But then there are also punitive damages, also called exemplary damages. They are awarded not to make somebody whole, but to punish the wrongdoer. For example, if the driver who crashed into you had prior history of reckless driving, then additional money can be awarded to you to punish this reckless driver. Okay. However, this is the important point. In procurement, liquidation damages can only be compensatory and not punitive. You cannot punish somebody for giving you a faulty lawnmower, although you can demand that the person compensates the organization, the person who sold you a faulty lawnmower, compensates you for the actual measurable damages that you have attained. Okay, so if you ended up hiring somebody to mow your lawn as a result of you buying this faulty lawnmower from another party, then that amount can be compensated. But if you're saying that, well, on the top of that, I want $1 million because I was so upset, I was so distressed, and I want to punish this seller, then it cannot be done because your distress, you being upset, is something that's not measurable. And your intention to punish somebody for this distress is more like a punitive damages. So that amount cannot be included in a final settlement amount awarded by a court. In addition to UCC, there is also something called Federal Acquisition Regulations, or FAR system. All projects funded by the federal government are subject to this system. Federal Acquisitions Regulations system was created to codify a uniform set of policies and procedures for the acquisition of supplies and services by the federal government. Now, some branches of the federal government have their own FAR extensions. For example, the Department of Defense has the so-called Defense Federal Acquisition Regulation Supplement extension. But in case of a conflict, FAR rules should prevail. The FAR system has thousands of pages. It's a very large document. It is divided into 8 major subchapters that are marked or labeled using letters A through H. And then subchapters are broken down into specific parts or regulations. So on this slide you can see just some examples of subchapters and specific parts within those subchapters relevant for procurement management. You can just pause this video for a minute and take a look at the list. Now, oftentimes in a procurement relationship, a buyer wants to have some form of guarantee that the seller will perform the needed service or deliver the needed product in accordance with the contractual terms. So this is often called not insurance but bonding. Now, bonding can be required by the buyer through two mechanisms or two arrangements: guarantor and surety. Now, when an organization requires the seller to have a guarantor, it means there is another organization that has a secondary liability for the performance of the principal. Now, the seller in this kind of relationship is called the principal. If the principal fails to perform, meaning the seller fails to perform what was promised on the contractual terms, the buyer should try to deal with the principal first. In other words, they need to work with the seller first to resolve the problem before going to the guarantor. So that's why the guarantor has the so-called secondary liability. Now, oftentimes the arrangement is through surety. Now, a party that falls into the surety category has a primary liability for the performance of the principal. The buyer can go straight to the surety if the seller or the principal fails to perform on the contractual terms. And in that case, the principal and the surety have equal standing, so performance of the contract can be demanded and delivered by the surety. So surety is like a stronger form of bonding, and many government organizations, they actually require surety and not a guarantor type of arrangement for bonding. Now, when it comes to the bonding itself, the kind of insurance or assurance that buyers want to have on the side of the seller, they're typically of the following types. For example, bid bonds, some kind of guarantee or insurance that the seller will actually deliver on a contract that was won through bidding, because it is possible that a seller will bid the lowest price, win the contract, and then just try to walk away. So a buyer wants to prevent those kind of situations from happening, and they may require some sort of bid bond insurance type of arrangement from the seller. Then payment bonds, being able to pay for labor, materials, and subcontractors, not being in a situation where the seller runs out of money. And then completion performance bonds, meaning the guarantee that the seller will actually finish the project. So a seller may request some kind of insurance against a situation where a seller fails to complete the project or finish the project to the end. Now, also some special terms or clauses can be inserted in a contract, and we will look at some of those special clauses. Time is of the essence. If this is inserted into a contract, it is used to indicate that time is critical, and it's often used in relation to time critical items. So when this clause is inserted, the seller must strictly follow the schedule, and no deviation from schedule may be accepted. Liquidation damages, something in relation to liquidation damages. A compensation for each day late with delivering a product or service can be inserted into the contract. Now, the damages can be only to compensate the buyer, but they cannot be punitive to punish the seller. Force majeure, inserted into the contract to prevent accumulation of damages for events that are clearly outside of control of both buyers and sellers. Some examples of that include acts of God, such as wars, riots, natural disasters. Who has authority to act on the contract can be specified in the contract as well. Typically, the buyer within an organization is responsible for contractual terms, while project manager is responsible for technical matters, but other divisions of responsibility and authority can be inserted into a contract. Also, a clause related to termination of contract for convenience can be inserted. One of the common reasons and well-accepted reasons for terminating a contract is failure of the seller to perform. So that's the most common reason. However, the buyer may also terminate the contract for other reasons. For example, if a better deal comes from somewhere else. But this has to be inserted into a contract. And usually, if a contract is terminated for something that is other than a fault on the side of the seller, then the seller will be eligible for some form of compensation. Otherwise, it will be a one-sided deal. Warranty information can be inserted. Now, warranty information is regulated by UCC. The type of warranty may be specified in the contract and the period of warranty, which is especially important. Also, something related to the right for inspecting the goods. Again, this is something regulated by UCC. Can be inserted into the contract. For example, a contract can specify where the inspection will take place on the buyer or seller side. Back charges. For example, if goods arrive damaged, the buyer may reserve the right to do the necessary repairs on their own and then charge the seller for all the costs incurred. Bonding and insurance. Performance bonds and other type of insurance may be required and may be explicitly mentioned in a contract. Also, progress payments, when payments to the seller should be made. It's usually tied to the seller's performance on the contract. As work is completed, payments are made to the seller. And then finally, contracts may include provisions for alternate dispute resolutions. Many disputes, especially commercial disputes, can be resolved without going to court. For example, some mechanisms for resolving disputes without going to court is mediation. The contract will say that the two parties will agree that one individual or one organization is both trusted and respected by both sides. So they will commission this organization to try to bring those parties together and resolve a conflict. Or sometimes they may opt for an arbitration, which is a bit closer to the court-like arrangement. They may agree on a panel of judges that will listen to the dispute and make a quick verdict on a dispute without going to court, because this may save a lot of time and money on both sides. So those are some additional contractual terms that can be inserted into a procurement contract. So that completes Chapter 9 video presentation.